like to introduce you to our moderator, Jeffery Daar. Jeff?
Yes, hello everybody. My name is Jeffery Daar. I'm a partner in the law firm of Daar Newman, Los Angeles. I am my firm's a longtime member of CONSULEGIS, and I'm currently the co-chair of the CONSULEGIS International Litigation Arbitration Specialist Group. Let me quickly set the scene today for our first webinar that CONSULEGIS has ever done. So we're very excited that everyone can be hearing this. And this is on basics of cross-border business transactions. Cross-border business transactions require more than just knowing how the transaction works in the country that you may be located in as the business person. You need to also know the added layer, the extra dimension of having more than one country involved with your transaction. There are additional dimensional issues such as different cultures, different language, different customs. What may look like a perfectly good contract for your transaction in your jurisdiction may not even begin to work in the other countries in which your partners are located. What you need to do to make your transaction work as intended is one of the type of issues that we will be addressing today. We are very fortunate today that we have three fantastic lawyers who are going to be joining our discussion. They're from three different regions of the world: Asia, Europe, and the Americas. I've also had the pleasure of knowing them and having closely worked with each of them for over 10 years plus in each of their cases. Let me briefly introduce our speakers, and then I'm going to tell everyone what we're going to be covering today, and then I'm going to also then briefly explain for those who don't know what is CONSULEGIS, who is the organization that is hosting our webinar today. Our first speaker, in addition to myself, will be Fernando Hernández-Gómez. Fernando is a lawyer from Guadalajara, Mexico. He's a founding partner of Vázquez, Aldana, Hernández-Gómez, and Asociados. His bio slide for everybody is at the end of the PowerPoint, by the way. Fernando is the current vice chairman of the advisory board of CONSULEGIS, which is a European economic interest group. Our next additional speaker is Marlies Hoecherl, who is a partner in Capital Law LLP, which is located based in Cardiff, United Kingdom, in Wales. And among her many accomplishments, she's a current member of the advisory board of CONSULEGIS. She's also a recent past chair of the CONSULEGIS Tax and Corporate Specialist Group. Our third speaker is Michael Lintern-Smith from Hong Kong. Michael is a senior partner at Robertsons, Solicitors, and Notaries, which is based in central Hong Kong. And among his many accomplishments, it's noteworthy he's the past president of the Law Society of Hong Kong. The topics we're going to be discussing today in a discussion-type manner based on the three different regions we have will include differences in business cultures, corporate structures and strategies, contract particulars and details, where and how to consider resolving disputes, arbitration versus litigation will be part of that, distribution and licensing agreements, as well as other noteworthy areas of concern. We will, if we have time, take questions, and there's an ability to type in questions. So if you have questions, please put them in as we go, and be patient. We will try to get to them depending upon our time at the end of the presentation part. Let me briefly, there you go, start our PowerPoint, which everyone hopefully is seeing. Let me just briefly tell you a little bit about CONSULEGIS. CONSULEGIS is an international network of professional independent law firms and in-house lawyers. The network currently comprises over 1,700 lawyers, and we have members in more than 45 countries in more than 150 cities around the world. And you heard at the beginning our managing director, Anka Braun. She's based in Munich, Germany, which is where CONSULEGIS has its central office. CONSULEGIS originally started in Hamburg, Germany as a European-based organization focusing on having the ability of members to be able to work with others who could practice outside of their own jurisdiction and with them. And it has, over the years, since 1990, expanded into a true international global network with firm members in literally all parts of the world. The mission of CONSULEGIS is to continue bringing a premium international network of independent, high-quality law firms. And we work for clients on cross-border or global transactions, including multinationals with subsidiaries in several countries. CONSULEGIS members often work together and put together cross-border teams of specialists. In CONSULEGIS, we have a number of very active specialist groups. They all have content, which you can find at the CONSULEGIS website. And the content includes newsletters. We have a business development group. We have, as you can see on the slide, a number of growing specialist groups, and these are made up of individual lawyers from the many different CONSULEGIS member firms, and those practice areas include aerospace, corporate and tax, international litigation arbitration, intellectual property, entertainment law and information technology, labor and employment, public regulations, and sports. We also have a growing number of regional groups where members work together and have, including individual local programs in their region. So, for example, we recently had our, I believe, third now European meeting of just member firms and interested people. We also now have a young lawyers group. And on this slide, I want to go over all these, but there are many benefits that we offer clients, and I think the most effective and important ones to note are when you deal with members of CONSULEGIS, you are dealing with lawyers who are specialists in their local jurisdiction. CONSULEGIS is very exclusive in the sense that we really screen and are particular as to who is allowed to be a member, and many considerations go into it, but the most important one is the quality of the lawyers. And we also strive to have lawyers who are local in the sense that they have the local relationship people would want with the local courts, the local governments. We also strive to make sure that our members provide high quality and cost-effective services. As I mentioned earlier, there's a wealth of information, including how to find CONSULEGIS member firms, its in-house lawyer members, advisors, as well as lots of content from newsletters to other materials, and you can find them at the CONSULEGIS website, which you'll see on your screen, and there's also the contact information for our offices in Munich. We're going to now go to our first of our discussion points under our topic of cross-border business transactions today, and we're going to start with a discussion on differences in business cultures. Business cultures in different regions can make a huge difference when you're dealing with people, including having an understanding and being open to different cultures. Everyone's cultures may be different than yours, and that may itself affect how the transaction gets put together and how it will work later, including issues of language. So let me start by turning things over to Michael Lintern-Smith. And Michael, if you could sort of give us some thoughts on how differences in business cultures are noteworthy for doing business in the Asian countries.
Certainly, Jeff. Thank you for that. Of course, you've given me a huge task today because you've given me a geographical area which comprises 30% of the Earth's landmass and covers 4.3 billion people, so no small task that you've assigned to me. Just some observations of my own from having been in Asia for the past almost 35 years, just short of that, operating out of Hong Kong and providing advice on transactions throughout Asia. Of course, you will all be aware of the history in Asia over the past 20 years, starting with the initial rise of the Asian tigers, Singapore, Hong Kong, Korea, and Japan, and then the massive rapid growth in industrialization in China, followed by the industrialization in Asia, and there have been huge changes within this region within the past 20-25 years. The developed economies, Japan, Korea, They've got their own established protocols. They've been trading with the West for quite some time, and they're quite used to dealing with the West. Other areas, they're not yet fully experienced, and you can see clash of cultures. Taking China as an example, there is a reliance on personal contacts in China. You may have heard the Chinese term guangxi, which means personal connections, and basically in China everything is done on personal connections. If you're going to make a contact with a business client in China, it will not happen overnight. It will be a slow progression, and there's a feeling that you have to get to know each other before you will commence doing business together. There is a reluctance to do business with strangers. It can be done. In other jurisdictions, there is less of that reticence. Indonesia is far more outgoing and far more welcoming of foreigners. And the new economies which we have opening up now, in Vietnam and Myanmar, they are more direct and they're more intuitive about doing business. Taking Asia in general, I think one point that needs to be borne in mind is that everything has to be spelled out clearly. The terms of any agreement you reach have to be absolutely clear, and you're not in a position to rely upon established business practices as you tend to do in the West, because you've been doing business with people from a particular culture, be it a national jurisdiction or be it a pan-European jurisdiction or even a trans-American jurisdiction. Those established practices that you have for doing trade and doing business are not necessarily in place, and you have to be prepared to investigate the practices of the other jurisdictions. With China, I've always said to clients, if you are doing business in China, just assume that everything will be 180 degrees opposite to what you expect it to be in the West, and you won't go too far wrong. That is a little bit glib, but it is not too far out of kilter. So it takes time to organize business relationships. You need to be prepared to put the time and the effort into that. Beware of all of the myths and the cliches that arise. You'll hear all about Chinese clients taking you out and drinking wine and giving you horrible things to drink and testing your prowess over the dining table. There is a little bit of truth in all of those things, but it's not necessarily the case everywhere.
Great.
Bear in mind that conflicts which arise, and they do arise, are almost always the product of misunderstanding, and therefore it's absolutely important and imperative to take the time to explain your viewpoint, to cover all of the aspects of your transaction. If you're buying products, if you're distributing, if you're setting up a representative office in China, you need to be absolutely certain that the person that you're dealing with fully understands the transaction. Hence, you need to spend the time and you need to put efforts into the relationship. Be very, very careful with interpretation. You're going to be dealing with people who do not have the same mother tongue as you have. Your interpreter becomes a very, very important person, and it's absolutely essential when conducting business transactions, negotiating contracts, or just concluding deals, that you have an interpreter who is first class and is fully conversant with the language of both. It is not possible, in my experience, to operate with two separate translators, each of one who has the mother tongue of the two parties. And another word of warning before I pass it on to someone else, currencies. You're going to be dealing in currencies which are different to the ones that you've dealt in before. Currencies fluctuate. Every Asian businessman will know, and they will have at his fingertips, the current exchange rates for all of the world's major currencies. They will know the US dollar to the euro, they'll know the baht to the Indonesian ringgit, and everything else. You're expected to be able to know those things.
Thank you, Michael, and let me turn to Marlies. And
I'll pass you over to someone else.
Yes, Marlies, if you can address in the broad scope, what do you think is worth noting for business cultures in European countries?
Yes, thank you, Jeff. I mean, Europe is, of course, nowhere near as large an area as Asia, so my task is, on the one hand, slightly easier. On the other hand, we are still faced with the fact that Europe is, of course, not a coherent entity. It's made up of many different countries, many different cultures, different languages, and also different business etiquette. It's maybe not as drastic as you have in different Asian countries, but you know, the devil is always in the detail. Just to give an example, there is a huge difference on how the balance between work and life or public and private life is seen. In the UK, there is sort of like a seamless continuation between your work life and your private life. The people you work with may be your friends. You talk about work when you go out in the evening. In France, on the other hand, there is sort of like a clear distinction, and to a certain extent in Germany as well, where your friends are your friends and your workmates are your workmates, and never the twain shall meet. We have, of course, the European Union, which has made business within Europe a lot easier because we've got free movement of goods, free movement on workers. We have European law, which is automatically applicable in all countries which are members of the European Union. However, all those laws are then implemented separately within those countries, and that can lead to problems. But there are also significant differences in the way business is done. And in my experience, you can literally see that there are clusters of countries. So the UK, strangely enough, is actually nowhere near as European as many other countries. And it's much, much closer in the way business is done to the US and Commonwealth countries. Spain and Portugal obviously have an affinity to South America and parts of Africa. Within Europe, you have clusters of countries where you find a lot of businesses done. Austria, for example, is sort of like a gateway to Eastern Europe, Hungary, Czech Republic, Slovakia. Within the Europe, UK, Germany, and Netherlands seem to be doing an awful lot of business together. Italy, France, and Spain are another sort of cluster of countries, and then, of course, you've got Scandinavia. It is important, as with Asia, to know about business etiquette, and although English is widely spoken and is generally sort of an accepted language of business, I think it's a fallacy to rely on the fact that everybody speaks English. I mean, as you can hear from my accent, I'm German, and I've lived in the UK for a long time, and I actually do spend quite a bit of my time translating English into English, where the terminology is just not easily translatable. Another example where there are differences are business meetings and how they're conducted. In the UK, you have a business meeting, people turn up on time, but they spend the first few minutes just having some nice, friendly chat about the weather before they go into it. In Germany, you're much quicker actually getting to the core of the meeting because you have to be efficient, and the meetings generally don't last as long either. In some countries, in France, and I do realize I generalize here, in France people might not turn up at the set time for the meeting, but 5-10 minutes later. If you want to sell, in the Anglo-Saxon world, you always prepare very shiny sales material, and the form is equally as important as the content. If you want to sell, for example, in Germany and also in parts of Scandinavia and also in Switzerland, you better take your technical guys along with you, because people are not that impressed with shiny material. They need to have data. They need to have hard evidence. So best take your engineer and your sales guy along. Basically, all of that is slightly generalized, but there are plenty of businesses in Europe where people are so used to global transaction that they will recognize each other's business etiquettes anyway. And you would be forgiven, for example, in Germany if you address people by their first name, which is obviously customary in Anglo-Saxon countries. But if a German person did that to another German person at the first meeting and addressed them by their first name, it might not go down quite so well. And I think that's really all I wanted to say about Europe.
Thank you, Marlies. Let's turn to Fernando in Guadalajara, who has the task of dealing with both the North and South American parts of the globe.
Thank you, Jeff. This is, as you know, the northern countries, Canada and the United States, are in culture a lot different from the southern countries, Mexico and south all the way to Argentina and Brazil and Chile, which are also more different than the Central American countries. So there's a lot of different cultures around. There's also very big differences in terms of legal systems. As you know, the North Canada and the United States are ruled by the common law system, whereas the Latin American countries are based on the Roman system. So our laws in the Latin American countries are codified. Everything is in the law. Most of the contracts are regulated by the law, and so the way the contracts are written and negotiated are also different. The southern or the Latin American countries are also more oriented in receiving foreign investment versus, the U.S. and Canada. The transactions are more into sending investment over, across the borders. In terms of language, I would say the common language for business is English. In most of our countries, every businessman would be able to negotiate in English. We've seen in the recent years that most of the European businessmen that come to our countries are being able to interchange their ideas and do business in Spanish. So that is helping a lot. And as of today, for example, in Mexico, the foreign investment for the first partner is the U.S., but the second partner is Europe. It's almost in the same amount, and that's probably one of the reasons that the way they are being able to communicate with the businessman. A businessman in our countries, in terms of meetings, like Marlies said, in the Latin American countries, we are used to sitting in the table and spending 15 minutes or so discussing about everything else but the business we are supposed to be dealing with, and that puts the parties involved in a level of comfort, and then when that's done, you go to the next subject, which is the business issues, versus if you're dealing with a Canadian or a U.S. partner, you better be able to go straight to the point and address the main issues of the discussion. In terms of deadlines, don't be afraid if a Latin American lawyer tells you they're going to deliver a contract one day and it's been delivered on the next day. The deadlines are more relaxed in the Central American countries. Even if we speak in between our countries in Spanish, for example, in Latin American countries, there is a lot of difference in the meaning of certain words. So be sure that instructions and concepts are being understood by all the parties involved before you are starting to write a contract. The personal knowledge, it's also very important. Businessmen won't like to go to the next step on a transaction unless they have a level of comfort in the personal side. Breakfast, food. I mean, food is a good thing to have around negotiations. If you want to have a shorter meeting, breakfast is recommended. If you want to have longer discussions, lunch is recommended. Dinners are not very common in the Latin American countries, but they are more common in the U.S. or Canada for discussion. I think that would be something that we would like to discuss about cultures, Jeff.
Okay, we're going to now turn to another topic, corporate structures and strategies, and let's go through the different regions as to what our panelists think is worth noting for the different regions and countries they include, and topics will also include the issue of setting up corporate headquarters. So let's this time start with Europe. If we go to Marlies, please.
Okay, thank you, Jeff. Yeah. Interestingly enough, I think in all European countries you have sort of like your limited liability companies, your public companies, your partnership, and people are sole traders. So on the face of it, it looks all very homogeneous, and you think, yeah, it's sort of interchangeable. Again, the devil is in the detail. I mean, first of all, you have in a number of countries sort of hybrids. For example, you've got open companies, which are a mixture between partnerships and limited liability companies. You've got limited partnerships, and the governing documents are actually quite different. Another difference is the time in setting them up and the administrative burden, so that changes from country to country. Liability of directors and shareholders can be quite different, and that's obviously something that's well worth investigating before you set up anywhere what your potential liability could be. The minimum share capital requirements differ. In some countries you can set up a company with sort of like €1, 1 penny. In others you have to put more startup capital in. If you have shareholders agreement and your articles, i.e. your governing documents, there is differences in Europe as to which document prevails if there's an inconsistency. In the UK, for example, the shareholders agreement generally prevails. In France, the articles would prevail. Security arrangements, i.e. if you give any security to your lenders, to your bank, they are very different from country to country. So if you have a group of companies, that can take quite a bit of time to sort it all out. There have been attempts at pan-European companies, and there is, in fact, you can have a European public company, a Solicitors Europea. And this is sort of something that a number of large corporates have taken up, for example, Allianz, BASF, Puma, Schneider Electric. There has also been sort of like an attempt by the European Commission to replicate that for limited companies, but I think because of the administrative nightmare and the lack of coherent registration, this has now been abandoned. So far we are not able to actually set up a European limited company. In terms of where to set up your headquarters, I mean, there's a number of considerations. There is obviously your commercial strategy, there is also tax strategy, and then there's sort of like the details around it, like employment law and so on. My take on this is don't let tax lead you, but look at where it makes sense for you strategically from a commercial point of view to set up your headquarters, because there's no point setting it up, say, in Scandinavia because you've got a fantastic tax break there if actually what you want to do is go into Eastern Europe or Southern Europe. In terms of where your product and market and your logistics are, it's probably easier for US and Commonwealth countries to enter Europe via the UK, and we've got actually a pretty good tax regime as well for inward investment, and you can set that up as a base then to go further into Europe. Equally, South American countries probably better to look for Portugal or Spain. And if you want to go into Eastern Europe, then Austria or Switzerland may not be barred. Tax consideration, of course, very important. In the past, people have obviously taken up sort of these tax havens, but there is sort of a strive to avoid that and make sure that there aren't any companies just setting up post boxes somewhere. And in fact, the UK is now introducing what is called the Google tax, where large companies actually have to voluntarily tell HMRC if they think that they should pay more tax. This is only for companies with a turnover of more than £10 million. And then HMRC will conduct its own assessment and decide how much profit is being diverted from the UK, and then the company will have to pay sort of like either 25% tax on that, or if they've paid something in advance, it'll be taken into account. So as I said, tax is maybe not always the best choice for that. Further considerations would be employment law. Some countries are have very, very sort of strict and employee-biased rules, so maybe not the best place to have a huge workforce. And then, of course, also the cost of setup and administrative burden. I think the next person then would be Fernando.
Thank you, Marlies.
Yeah, so let's turn over to the North and South Americas. Fernando.
Okay. Well, in terms of corporate structures, we have different ways to limit the liability. Most of the companies are set up that way. If you want to do, you're setting up a structure where it involves different jurisdictions, for example, the U.S. or Mexico, you may use a different type of company, which is a limited liability company that allows to pass through with the U.S. entities, and that way the U.S. investors will be able to account for everything, all the business from the U.S. entity. So it's important to learn where the funds come from, where are the dividends going to be paid, how are you going to allocate the money from the shareholders, if it's going to be capital or if it's going to be loans, and that would have to have the tax schemes involved, because there are a lot of tax implications in the different jurisdictions. If you are going to set up a company in the Latin American countries, there are the statutes and the public, has to be formed by means of a public deed, which is a very formal contract that has to be done with a notary public, and there are different registrations that require to be done before the company is able to start doing business. In the U.S., it's more flexible, articles of incorporations or bylaws, and they are registered before the Secretary of State, depending on the state. For headquarters, most of the U.S. companies, as you know, Delaware law, it's very friendly in terms of dealing with investors and minority rights and protections, and so it depends how you want to structure, and depending on the sector, where you want to keep the assets, and so it depends on a lot of issues, and you have to be able to learn all of those issues before you decide on how to structure a company in either of these jurisdictions. Legal representation is also very different depending on if one is in the U.S. or Canada or the Latin American countries. The managers of a company have a lot of responsibilities, and the way the authorities and the powers of attorney are granted to each of the officers it's also very important. It has to be done separately. So just appointing a person as a board member, for example, does not allow or does not grant this person authority to act on behalf of the company. So the way the powers of attorney are granted, it's also a very important issue. Jeff.
Okay, let's then turn to Michael Lintern-Smith with
Foreigners cannot purchase land in Thailand. Can well be similar. Philippines and Indonesia, similar system, similar to the concept of the Société Anonyme in French law, VAHG in Germany. And there is a lot of regulation. There's a lot of proofing of documents have got to be sworn before notaries, and it can be pretty difficult to set up a business venture. If you're going to take advantage of laws providing for limited liability companies, it can be even more complex. So there tends to be a lot of red tape and paperwork. And distribution of products manufactured overseas and manufacturing of goods within China. So WOFI works. You do not have to be a partner with a local venture as you used to have to be in the days in which China was opening up, the late 80s and early 90s. But there are still a lot of restricted areas. I have a whole list in front of me of restricted foreign industries. There are various industries that you cannot go into. Farming and mining are most obvious ones. You can do that with local partners, and there's a whole list of things that you cannot do at all. Obviously things which are strategically important, which you cannot involve yourself in power, gas and water in China at all. And there are other restrictions, for example, in educational services. So China can be difficult from that perspective. Also, you need approval for investments through the central government. There's an organization called MOFCOM. That was the major change of 12 months ago. There's no need to get central authorization for investments into China. It can now be done by the local branches within the respective provinces. But be careful also, unless you set up a WOFI, if you're hiring staff to promote your goods, you have to go through the Foreign Labour Employment Agency, an organization called FESCO. Other types of business structures, forget about trusts. The concept of trust is unknown outside of the common law world. You're fine in Singapore. You are fine in Hong Kong if you're going to set up trusts. But the rest of Asia is very, very suspicious, with the possible exception of Malaysia. So Hong Kong and Singapore have a different approach, a common law approach to setting up companies. Pretty simple to do. Hong Kong also revolutionized its corporate structures 12 months ago, and we now have the concept of single-person corporations. It's very, very easy to set up, and it's very, very easy to get rid of limited liability companies. The concept of shelf companies, which you have in England, permeates through to Hong Kong and to Singapore. The reason that made it even easier to administer companies while still keeping the guard on directors' liabilities is that there has been competition in Asia through British Virgin Islands and Cayman companies. You will see them everywhere. There are probably more companies operating in Hong Kong which are incorporated in the BVI or the Cayman Islands, and occasionally Bermuda and other offshore structures. And these are used very much as holding companies. With regard to China, absolutely everybody who is doing business in China needs to have a holding company in Hong Kong. If you don't have one, then you are totally crazy. There are lots and lots of reasons: simplicity of structure, easy to set up, easy to administer. You're dealing with a currency in Hong Kong which is fully convertible, the Hong Kong dollar, whereas in China the renminbi is restricted, and you have currency restrictions in a lot of Asian jurisdictions. You limit liability, and of course there are tax advantages, and you have access to a legal system which operates pretty well for dispute resolution if you are structured in Hong Kong. So that tends to be the way that most of the investments are done for going into China, and that is being echoed in investments which are being made out of China and which are being taken overseas. Be careful of the concept of authorized representatives. Quite often you may have a board of directors, but you have to give almost absolute and autocratic power to someone who is the authorized representative. This will be the person who is recognized by the local authority as having the total power to bind the company. This exists in quite a lot of jurisdictions. You see it in Vietnam, you see it definitely in Myanmar, and you have a problem. Do you appoint a local person, a Chinese national, or someone from the jurisdiction into which you are doing your investment? Do you appoint them as the authorized representative, and you put yourself at risk of that position being abused? And we are currently litigating on a lot of areas where the authorized representative has gone outside his authority and has engaged liabilities on behalf of the company, which he wasn't supposed to. Or do you do the opposite, which some persons do? You have the foreign national recognized as the authorized representative, and then if things go wrong and there are problems with the authorities, the consequences can be quite savage for the authorized representative. So, as I say, difference in approach between common law countries. Singapore operates pretty similar to Hong Kong and performs a similar system of holding companies for investments in Indonesia and the emerging Southeast Asian economies.
Great. Let's turn to another topic, issues of what particulars are worth noting to make a contract work in different regions of the world, including issues such as language requirements. And this time, let's start with Fernando, and if you could sort of touch on what you think is worth noting in the Americas.
Thank you, Jeff. Well, when you're doing a contract in the Americas, if you're dealing with the U.S. or Canada, you can expect very long agreements, not like sometimes in the U.K. where there are much simpler, short, less pages. If you are involving a Latin American jurisdiction, you can expect that many of these agreements would have to be in the form of a deed granted before of a notary public. The notary public in the Roman system is a lot different than in the common law system, where in the common law system, you know, it's secretary in an office could be a notary, and basically all it does is just attest the person signing is that for real, and it's not a different person. Whereas in Mexico, the notary public is a qualified attorney, has to do a very special exams and admitted to have a special license to attest agreement, and they have a formality, and the form of the agreement is very, very important. If it's not done in the proper way, the agreement will not have legal effects. So the notary public figure, it's one thing to consider because it also involves you know, more fees and also sometimes taxes. The notaries have to withhold taxes and then pay the taxes to the government when there are taxes involved in the transaction. Another thing to consider would be authentication of documents and legal representation. If you're dealing with you know, different parties, like for example, a company in the U.S. and a company in a Latin American country, the way the legal representation is granted, and in order to be effective in a different jurisdiction, you have to authenticate the documents, and they have to be translated because the official language in Mexico, for example, and the Latin American countries would be Spanish. So even if the contract is done in English and you want to go to court, it would have to be translated before an official translator. And the documents to be valid in a different jurisdiction would have to be apostilled, except in Canada, because Canada is not a party of the Hague Convention, so that takes a lot more formalities with consular you know, authentication. In terms of choice of jurisdiction, our systems allow to choose any jurisdiction, but it would definitely depend that is not real estate involved, because if there's real estate involved, the place of jurisdiction should be the place where the real estate is located. If you're doing a contract that involves collateral, again, the jurisdiction and the laws that would apply for that collateral agreement would be the local laws. Another thing to consider are local laws. In Mexico, for example, most of our commercial laws, or all of our commercial laws, are federal law, whether like in the U.S., for example, most of the laws are state law. So in our case, it's easier because all the contracts will be regulated under the same law, no matter where you are conducting the business or where you are dealing with the contract. In either part of the country, it would be the same law that would apply if it's any commercial matter. And again, like we said, most of our commercial matters are regulated in a codified status. So if you forget to write something in the contract, it's more likely that the law will state how it should be interpreted. In the U.S., for example, representations and warranties are a very essential part of an agreement, and the things that the parties disclose and don't disclose are very important in the common law system. So nowadays we are getting more used to the U.S. Way of writing agreements, and you can now see agreements in Latin American countries written in a very similar format than the agreements are written in the United States, because of the way the culture has been getting to our countries in doing more business and interchanging more transnational, international transactions.
Thank you, Fernando. If we could turn to Michael for the Asia countries.
Asia tends to be more relaxed with regard to private contracts, and will generally enforce agreements which have been made voluntarily by parties who were not at any disadvantage in negotiating the contract. In the early days, when we started doing business in China, to use one-page contracts. I mean, I could write one from the top of my head. Party A agrees to provide the capital. Party B will provide the manpower. Party A and B together will manufacture goods and sell them, and the final contract clause would usually be if a dispute arises, the parties will work together to try and resolve it. It took some time to get them educated into Western ways of drawing contracts and dealing with important heads that had to be discussed, had to be included in the contract. Typical things that you do these days, things you'd have to consider and have agreed, and which you'd reduce it to writing. Say, for example, for a distribution agreement, obviously you have to consider the territoriality. I mean, which area are you going to allow the goods to be distributed? You have to define the goods, and you have to provide for the supply of the products, because there has to be a constant supply assured that the goods can be marketed. Obviously, most importantly, you'd always put in payment of the products. And that can be problematical. In the early days, goods manufactured in China, for example, were almost always paid for by letters of credit, but they've become more and more suspect. Quite often fraudulent documents have been used, and goods have been laden and shipped overseas, and quality control certificates and most certificates have not turned out to be authentic. 30-day, 60-day, 90-day credit payment terms not used to be popular, but less so these days. Manufacturers in China have become aware of the influence which they have, the dominant position they have in the market. It's becoming more and more common, particularly in the garment industry, to do payment for the goods to be manufactured. You've got to deal with, obviously, in all cases, you've got to look at the intellectual rights. Look at the intellectual property rights governing the goods. To what extent are you going to license the use of the intellectual property rights? There are some horror stories.
Está chingón, ¿no?
I'm sorry, Fernando, if we could mute your phone.
¿Cómo las cachas? Tienen que ser...
No, esta me invitó, no, pero... Ahí
I don't know. Somebody.
There have been some horror stories where parties have failed to register their intellectual property rights, their trademarks. Again, as I said earlier, beware of myths. I mean, there is an old myth that you can register Coca-Cola and demand a huge payment. Most jurisdictions in Asia, in fact almost all of them, if you register a trademark, you have to show that you have prior use as well as prior registration. So it's not as simple as that. It's a nice urban myth, but it's little more than that in my experience. If you're distributing goods, you have to look at support and training. Who's going to train the staff? Who's going to pay for the costs of that? And then you have to look at the standard ones, which is going to be the governing law. Choose the jurisdiction where you feel comfortable, where you can get an adequate resolution of any dispute which arises. Do you consider alternative dispute resolutions? And duration of the agreement is very important, and obviously always the most important clause. We lawyers usually put it at the end of any agreement, but in my case, it's usually the first one that I'll look at. I go to the termination provisions, because when clients come to see lawyers at some point in the future, having asked them to draw up the agreement, if they come to see them again in relation to the same agreement, it's usually because they are considering termination, and the requirements for termination have to be pretty straightforward. Beware of clauses which say parties will work together to try and resolve differences. As I said earlier, they were common in the early days in China. You do tend to see them in European agreements, that you have to give what the French call a mise en demeure. You have to put the other party on notice that a difficulty has arisen and requiring the other party to remedy it. Lawyers hate those clauses because it means that you cannot resolve any disputes. We prefer to go to court, get a quick, sharp knockout punch, and do something positive to try and get the matter resolved. Those type of clauses prevent you from being able to do that. So private mediation, generally in my view, not a particularly good requirement to have in there, and as always, it's terms as to payment which cause the most difficulties.
Thank you, Michael. And of course, one of the things we're not addressing in today, at least yet, is the Convention on the International Sale of Goods, the CISG, or the often referred to as the Vienna Convention on Sales, which applies to probably almost every country that will be discussed today, which you can exclude in your contract. So let's turn to Europe, and what's noteworthy in Europe with Marlies, please.
Well, thank you, Jeff. There is really not an awful lot I can add that hasn't already been said. The same problems that Fernando and Michael have already addressed also apply in Europe. We've got, on the one hand, the issue that we've got different legal systems. We've got common law system in England and Wales. We've got codified law in most of Central Europe. On top of that, however, we also got this level of European law, which, as I said earlier, is instantly applicable to all members of the European Union. And to add confusion, the member states usually do what we call gold plating. So a bit of European law governing contracts comes out in certain wording, then the individual member state looks at that, makes its own law based on it, but adds things onto it to make it even more shiny and attractive and wonderful and great and learned. But because it does it in a slightly different way to the other European country, we already faced again with differences in law, which can obviously lead to confusion and dispute. So, you know, just because something is based on European law doesn't mean it's the same in each country. So you have to be very wary of that. Language has already been mentioned. It's always important if you use different languages to make sure that you put in the contract which language prevails, so when it comes ever to interpretation of the contract, we know which language to look for. Execution, obviously, as already been mentioned, differs widely. In the UK, we basically just sign, or if you have to sign as a deed, we do it by 2 officers of a company or in the presence of a witness. In most Central European companies, you need to have your documents notarized, and again, it differs from country to country what kind of document needs to be notarized. Some contracts have to be in writing in order to be enforceable. For example, in Italy, if you have any kind of food-related contract, it has to be in writing. Some contracts have to be registered. For example, if you want to enforce a retention of title clause in Switzerland, you have to make sure that it is registered. So basically, what you also need to know is if there are any laws in the country that you're doing business with which override. So even if you have a choice of law clause which says the laws governing the contract are the laws of Sweden, and then you do business in Italy, you need to know whether there are any laws in Italy which override whatever the contract or Swedish law says. So again, very important to do your due diligence and get somebody with experience of the country you're doing business with.
Thank you, Marlies. Our next topic, where and how to consider resolving disputes. Do you want arbitration or litigation? Obviously, having a good dispute resolution clause in your contract may be critical to whether your contract actually plays out as you intend. And it's really not as much to have a place to resolve a dispute. You want to have a good provision that makes people perform because they know they'll be held accountable. So you avoid disputes by having a good dispute resolution clause. So in the context of arbitration versus litigation, do you want your dispute, if you had one, private or public? If your transaction involves, for example, trade secret information, how important then is it to have a means of effective provisional remedies such as injunctive relief? Will there a judgment, if you don't have an arbitration provision, a judgment in the different countries that may be parties to your transaction, will it be enforceable where it matters? And will that be something that will not make someone perform because a judgment in your country may never be recognized and enforced in the other person's country? If you have an arbitration, on the other hand, you have an arbitration provision. There's been a long time New York Convention since 1958 on the recognition and enforcement of arbitral awards, and more than 160 member states, virtually anyone we could think of, is a signatory, which gives some predictability as to actual recognition and enforcement of an arbitration award. So with those type of issues in mind, if we could have a quick comments from the different regions, we'll start with the Americas on thoughts on arbitration versus litigation and other type of related dispute resolution issues.
Thank you, Jeff. Well, like you said, the arbitration clause is the most important thing, and or an arbitration agreement if it's done separately. But if you write that clause or that agreement in the proper way, you will save a lot of time and avoid the possibility of having a litigation just for the purpose of knowing if the arbitration agreement is valid or not, which is often the case in the Latin American countries, specifically in Mexico. Our law is uniform. It's based on we have a federal law that allows for the arbitration, and it's based on the UNCITRAL uniformed law, so it's standard for most parts of the world. Currently, if parties often go more for litigation, they prefer going to court than doing an arbitration. Although that trend has been changing over the last years, but it's still people are not very used to doing arbitration. Now there are new laws or rules that allow different and faster arbitration procedures for smaller contracts, for disputes, for dealing with smaller amounts. So that makes it cheaper, makes it faster, and I think the new generations will be able to have this trend and have more lawyers preferring arbitration procedures. When you are dealing with an international transaction, it's completely different, because in those cases the arbitration is the most preferred way to resolve disputes. And for example, the ICC rules work very well, and they administrate the arbitration procedures very well in Mexico. So that would be our recommendation if you're dealing with a business and you want to have the arbitration done in Mexico. Often, you know, if we do business with the northern side of the Americas, New York is a very preferred place for the arbitration, and you want to stick to the international rules and not always the, you know, AAA or other more American types of rules. So selecting the rules is also a very important issue when dealing with the arbitration. And you want to have an arbitration that speaks your language, and so not always having one arbitrator works if you're dealing with an international transaction.
Thank you, Fernando. Real quick thoughts from the Asia perspective. Michael.
Well, arbitrations jurisdiction and deal with common law-based arbitrators, and China is very, very comfortable stage in them in Hong Kong also. My experience has been that time delays can be quite extensive. The usual arbitration clauses has 3 arbitrators, and getting 3 arbitrators to do what a judge can do in an afternoon usually takes about several weeks. And it turns out to be far more expensive. If you go to court, you get the courtroom for free, you get the judge for free, but everything that you do, which the arbitration center does, and in Hong Kong it's a privately funded one, and therefore they charge you for all of their services, and it works out more expensive and it's slower. But a word about Singapore. Singapore is state-of-the-art. Singapore is promoting itself very, very forcibly with regard to being the dispute resolution center of Asia. They have the arbitration center in Singapore. They do a lot of promotion, and they can afford to do that because they are totally funded by the Singapore government. And the facilities are excellent. That's not to say that in China the arbitration facilities are not excellent either. They have state-of-the-art. But in Singapore it's quite impressive. It's quite good when you're standing there addressing the arbitrators and you see the words which you're speaking, and you know, you can speak as quickly as I normally do, and yet the words are coming out on the page, on the screen, right in front of you. So Singapore is promoting that, and they've taken it one step further. Singapore now has an international commercial court, and they haven't yet looked at the enforcement aspect of it, but they are recruiting judges from common law jurisdictions, and they're inviting the whole world, bring your commercial disputes to Singapore, and we will adjudicate upon them, and then we'll look at ways in which you can enforce them overseas.
Great, thank you, Michael. Let's turn to Marlies in Europe.
Europe, yes, I'm not a litigator, I have to say, so I try to be very quick about this. One of the difficulties in Europe in litigation is that we have different systems. We have, on the one hand, in the common law countries, like England and Wales, the adversarial system, where 2 advocates basically represent their party's position before an impartial judge or jury. Whereas in the Roman law countries, you have an inquisitorial system where a judge or group of judges investigates a case, and that's obviously quite a different process. In the UK, litigation can be very expensive because not only do you have your solicitor representing you, you also then have the barrister. Those are the people wearing the wigs that everybody sort of like still is baffled about in non-Commonwealth countries, and it can all work out very, very expensive. However, arbitration is not far behind as far as expense is concerned. And we also have that additional problem that, as you already said, Jeff, that arbitration is governed by the New York Convention, but the litigation in Europe is covered by the Brussels I regulation, which has just recently been recast. And even though the Brussels regulation recognizes that the New York Convention applies for arbitration, there is still a problem in enforcing it. So you could actually end up with a situation of a conflict where one member state recognizes an arbitration agreement and the other member state court does not, and then you can go back to court and fight out in court whether or not it applies or not, and then whether or not the judgment ought to be enforced under the Brussels regime and the award under New York Convention or not. So it can be a mindful. Personally, I actually quite like mediation, although I wouldn't necessarily put it as a contractual clause, but I think it should be open to the parties, and that can quite often lead to a relatively inexpensive dispute resolution.
Thank you very much. Let's turn to another topic. And try to do this real brief since we're don't want to be over time. Thoughts on what's noteworthy in your region for distribution licensing agreements, including what needs to be in them to comply with laws or be enforceable. If we get really short and quick with Asia, Michael?
You've been really short and quick, Jeff, because I think I dealt with it, anticipating the time difficulties. I've dealt with it before. I've taken you through the main heads and the things which are there. Nothing really to add to that, thanks.
Very good, thank you. In Europe, anything, Marlies?
Europe, just very, very quickly again, is the gold plating problems. We've got European law, for example, governing anti-competitive practices, and that's implemented differently. But there are a few sort of like good guidelines how you can overcome European competition law, as long as you've got a distribution agreement where you don't have too many restrictions. And I don't want to get into the detail, but you've got to know what they are.
Perfect. And how about in the Americas, Fernando?
Short things to say, Jeff. Competition law is very an issue to be concerned. There are different new restrictions. Exclusivity clauses are very restrictive. Penalties can be very high if you don't do the distribution agreement properly. You want to be also concerned on how the pricing is dealt with, the way the prices are set and the way the prices can change, and the margins that the parties are going to keep or allocate. Those are things that could be considered as anti-competitive and have very big penalties involved. So I think that would be something to consider. On another hand, distribution agreement could be an easier, faster, and simpler way to put a first step in a Latin American jurisdiction with less formalities than a franchise agreement, for example, or with more protections than a simple supplying agreement. So things like that are to consider.
Okay. Turning to our last topic, a quick thought on what noteworthy areas are there to have in mind of concern? What are the traps for the unwary maybe in your regions, and any closing thoughts? And let's start this time with Michael in Asia.
I think the traps I've tried to outline already. I think it's kind of, if you're dealing with a partner from a different culture, it's kind of like falling in love with a woman from a different continent. The big things that attract you to each other are quite often the things that can end up driving apart. Cultural differences are important to explore in the beginning. If you don't cover them and if you don't deal with them, then you are likely to find that those differences drive you apart. I think, though, the main point I'd like to raise here is with the changes that are happening in Asia. Whereas Asia was once an area of cheap manufacturing, what happened with Korea and Tokyo, which became very, very sophisticated manufacturers. And the same thing is happening with China. Whereas we were dealing with a lot of clients who were moving into China and were setting up manufacturing bases there. China's starting to become rather expensive. It's starting to become the high end of the market too, and consequently they're moving to the newer jurisdictions, Myanmar, Vietnam, and Bangladesh are the places where you get your t-shirts and your cheap blue jeans these days, whereas China has quite sophisticated products. And also you have the same pattern that you had with Korea and with Japan. China has a lot of money, and they're starting to do outward investment. It's a market which Europe is already becoming aware of, and certainly USA is already aware of. And it is not just going to be property investment which you're going to be seeing from Asian sources. You're going to be seeing Asian manufacturers or Chinese manufacturers in particular coming into your jurisdictions in a big way and pretty soon.
Great, perfect. Let's turn to Marlies in Europe. Any closing thoughts or areas of concern?
Yeah, I just wanted to briefly mention two pieces of legislation which are UK legislation, but they affect every organization doing business or carrying on business in the UK. So even if you are based in China or in Africa somewhere, if you do business in the UK and if you're a certain size, they may apply to you. The first one is the UK Bribery Act, which sets a very, very high standard and basically makes it an offense to prevent a bribe. The penalty is a limitless fine, and it does not only cover the actual person, the actual corporate body, but actually also persons associated with the corporate body, so employees, officers, but also contractors, distributors, agents. The only defense that you can show is that you had adequate procedures in place to prevent bribery. The second one is very hot off the press, and that's the Modern Slavery Act 2015, which has only very recently come into force. In fact, some of it is not in force yet. But again, that applies to a commercial organization which supplies goods or services and carries on business in the UK. There is also a further requirement for a certain turnover that has not been set, and I'm hoping that to start with it will be a rather high turnover, because it puts quite a lot of administrative burden on the organizations. You basically have to prepare every year a slavery and human trafficking statement, which sets out the steps that the organization takes during that financial year to ensure that slavery and human trafficking is not taking place in any of its supply chains and in any part of its own business. So you can imagine if you have a large supply chain and if you habitually import goods from countries where there is an issue with slavery, then you have to probably prepare quite a lengthy statement. You have to include in that statement information about the organization structure, any policies that you have in relation to slavery and human trafficking. So I think we'd be spending a lot of time drafting these policies. Any due diligence you carry out in relation to slavery in your business and supply chains, and any parts of your business where there is a perceived risk of slavery, and also the effectiveness in ensuring that slavery and human trafficking is not taking place. So as I said, that's very, very new, but this is again part of the strive of the UK, and I think this is sort of like more a global phenomenon, the strive to better corporate governance and eradicate cross-border crime.
Excellent. And last, let's turn to the Americas with Fernando, please.
Thank you, Jeff. I would like to address just one issue, completely different from what Marlies is talking about on slavery or anti-corruption regulations. If you are thinking on a global transaction involving a global purchase agreement where there are companies buying out other companies in different jurisdictions, and that involves a South America jurisdiction, I think it's important to mention that regardless the global agreement, there also has to be ancillary agreements. These are local purchase agreements involving the local assets or the assets just for that subsidiary or affiliate company in that specific jurisdiction, and this is concerning also specific local taxes that are involved. So it's important to consider when you are allocating the price in a global transaction not to allocate the price of the affiliate in those jurisdictions until you have cleared all the tax issues and making sure you have this local agreement in place, because there are some tax filings, tax returns, and other filings that has to be done upon closing. So I think that's a very particular issue that is important to mention.
And of course, as the North American moderator here, it's very important to be aware of the Foreign Corrupt Practices Act, commonly referred to as the FCPA in the United States, which is also highly enforced by our Securities and Exchange Commission, and therefore is far-reaching knowledge for everyone to be aware of. With that, let's turn to, we have one or two quick questions, and we are going to conclude today. First question, and we'll keep it real short, is do we have any information to share on corporate structures in Malaysia? Asian question, and I will just start by mentioning that you will notice that CONSULEGIS has an excellent member that's based in Malaysia, but we do have our Asia expert, Michael Lintern-Smith. Michael, any thoughts on that?
Not an expert. Okay. Structure. Yeah, please that I'm aware of. Provide the details of our of. But yeah, we're a member in Kuala Lumpur who can give specialist advice on that subject.
And quick last question, and it's directed to Fernando. Are there any special terms of art that are worth noting when drafting contracts or dealing with contracts between the United States and Mexico?
No, I think dealing between the United States and Mexico, we are very familiar. I think we have a standardized way to, I mean, we would use a contract, would have the form more of a U.S. agreement, even though if it's in Mexico, it'd be written in two languages, and the Spanish language will prevail over the English if the jurisdiction is in Mexico. Again, I think you know, the representations and warranties, which are an essential part of the U.S. agreement, are now being adopted in the way we now draft contracts. But I think it would depend on whether the applicable law would be Mexico, and that, of course, would imply different concerns and probably the need of different formalities.
Thank you very much, Fernando. This concludes our webinar for today. Thank you, everyone who's been participating and who listens to this in the future. Thank you very much to our speakers. You've all been fantastic, and you can see why you are people I personally think are brilliant and fantastic to work with. For the people listening to this, this is the very first CONSULEGIS webinar. We will be having many more. Obviously, the different topics we discussed today could each be their own hour or more of discussion, so please look forward to having more opportunities to hear from experts around the world on international business and international law type issues. Thank you very much.
Oh, that's why I tried a couple times to